Mandatory reporting of child abuse. All children deserve to be nurtured and kept safe by those responsible for their care. Most parents and caregivers can provide adequate care and protection to their children. However, some parents struggle to keep their children safe and well cared for. Sadly, there are children across our state who face threats to their safety from within their own home. These vulnerable children rely on others, relatives, neighbors, and community professionals, including mandatory reporters, to help ensure their safety. This video is a brief overview of mandatory reporting of child abuse in Oregon. You, as a mandatory reporter, should not rely only on information in this video, but should also consult the child abuse reporting law to more fully understand your responsibilities. You may also reference the DHS guide, What You Can Do About Child Abuse. Approximately 75% of all child abuse reports are made by mandatory reporters. Mandatory reporters are public and private professionals required by law to report suspected child abuse. Most of these professionals interact with children and families on a regular basis. They include full-time and part-time employees, as well as volunteers. Some examples of mandatory reporters include medical practitioners, law enforcement personnel, employees of a public or private organization providing child-related services or activities, public and private school employees, and members of the clergy. For a complete list of all mandatory reporters, refer to Oregon Revised Statute 419B.005. Under Oregon law, any mandatory reporter must immediately report suspected abuse if that person has reasonable cause to believe a child they come in contact with may have been abused, or a person they come in contact with may have abused a child. Not every person is a mandatory reporter, but everyone is urged to report suspected child abuse to ensure the safety of children in our community. Now, let's talk about child abuse. A child is defined as a person under 18 years old. Child also includes a person under 21 years old who lives in or receives care or services from a child caring agency. A child caring agency refers to a private agency or private organization licensed by DHS, including residential care or other similar care or services for children. Even though you may have concerns about a child, it's not always clear whether abuse is taking place. Let's take a closer look at the definitions of child physical abuse, sexual abuse, neglect, mental injury, and threat of harm. Physical abuse is defined in Oregon law as any assault of a child and any physical injury to a child which has been caused by other than accidental means, including any injury which appears to be at variance with the explanation given of the injury. As defined in Oregon law, sexual abuse includes subjecting a child to sexual contact, rape of a child, which includes but is not limited to rape, sodomy, unlawful sexual penetration, and incest. Sexual exploitation, including but not limited to contributing to the sexual delinquency of a minor and any other conduct that allows, employs, authorizes, permits, induces, or encourages a child to engage in performing for people to observe. It also includes photographing, filming, tape recording, or other exhibition that, in whole or in part, depicts sexual conduct or contact, sexual abuse involving a child, or rape of a child, but not including any conduct that is part of any investigation or is designed to serve educational or other legitimate purposes, and sex trafficking, including allowing, permitting, encouraging, or hiring a child to engage in a commercial sex act or to purchase sex with a minor. Neglect of a child includes, but is not limited to, the failure to provide adequate food, clothing, shelter, or medical care that is likely to endanger the health or welfare of the child. Neglect also includes buying or selling a person under the age of 18. Neglect can be permitting a child under 18 to enter or remain in or upon premises where methamphetamines are being manufactured. Finally, neglect can mean unlawful exposure of a child to a controlled substance or to the unlawful manufacturing of a cannabinoid extract that subjects a child to a substantial risk of harm to the child's health or safety. Mental injury is any mental injury to a child that includes only observable and substantial impairment of the child's mental or psychological ability to function caused by cruelty to the child. Threat of harm is when a parent or caregiver subjects a child to a substantial risk of harm to the child's health or welfare. Remember that children often can't or won't speak up if their parents or caregivers are abusing them. They rely on you and others in the community to recognize something isn't right and to act to help protect them. Any single concern may or may not mean that abuse is occurring, but observing any of these indicators, especially when more than one is present, should prompt you to think about what might be happening. Consider each potential indicator within the context of what is typical for the child, their family, their culture, and their community. You do not have to be certain about abuse to make a report.
Hi, I'm Edgar, and I've been a school teacher in Oregon for many years. And because I interact with children as part of my job, I'm also a mandatory reporter. I enjoy getting to know my students and their families. Helping a child to learn and grow is one of the best parts of my job. So when I have a concern about how a child is doing, or I'm worried about what might be happening at home, I take that concern very seriously. Of course, when it's a small concern, I speak to the parents to understand if we can support them or if they need help. But when the concern about the student is bigger than I can address on my own, or the student has spoken to me directly about a concerning situation at home, I consider making a mandatory report of child abuse. I try to remember the process like this: recognize, record, and report. This three-step process helps me stay focused on what I need to do to fulfill my obligation as a mandatory reporter.
Let's talk about the first part of the process: recognize. Recognize is knowing the signs that abuse may have occurred or may be occurring. As we discuss how to recognize common indicators of child abuse, it is important to also recognize that each of us has our own beliefs about what constitutes good parenting, children's rights within their own families, and how we believe parents and caregivers should react to issues of concern. These beliefs come from our cultural and community norms, our own family experiences, and other life experiences. Of course, there are many ways to raise a child, and approaches to parenting vary widely throughout different communities. When we have a concern about a child from a different culture than our own, or who belongs to a community that we don't understand well, we should consider whether the concern relates to parenting practices and personal beliefs that may be different from our own, but are not necessarily abuse. Research suggests that child abuse occurs across racial and ethnic groups at similar rates. However, when we look at who is reported for abuse, we see that children of color, particularly Native American and African American children, are reported far more often than expected. This is called racial disproportionality. The following explains what is known about racial disproportionality in the child welfare system and how you can help correct this problem in Oregon. In child welfare, the word disproportionality means that certain groups of people are either underrepresented or overrepresented in our system when compared to their peer group in the general population. In Oregon and across the nation, children of color are overrepresented in the child welfare system at alarming rates. African American children are almost twice as likely to be the subjects of abuse allegations than are white children. In addition, once a call comes in about an African American child, it is more likely to be substantiated, and that child is more likely to be removed from home and stay away from home longer than a white child. There are almost 3 times more abuse allegations of Native American children than of white children, and Native American children are less likely to achieve permanency. As a professional interacting with children on a regular basis, it is critical you understand personal bias and how it may affect you as a mandatory reporter. Ask yourself, have I always called to report my concerns of abuse when I believed that a child was in danger? It is vital that you do not hesitate to call if you truly believe any child is in harm's way due to abuse. Ask yourself this question: all things being equal, would I make the same call in the same way if I saw the exact same things happening in a white family? Often, cultural differences equate to parenting differences. One culture may speak to their children in a manner that seems louder, harsher, or less familiar to a mandatory reporter. But those differences in parenting may not constitute abuse. We all harbor personal biases. Whether we like to admit it or not, we all grew up being bombarded by images and messages driven by racism, prejudice, or racial privilege that we may not even be aware of. Think about the messages that have infiltrated your belief system. Be honest with yourself. Do you believe, even a little bit, that Native American people actively seek government handouts rather than jobs? Do you believe that most Hispanic people are undocumented? Do you buy into the notion that African American men are more likely to be aggressive, or that all Asian women are passive? Do you worry that different racial or ethnic groups are somehow a threat to your personal prosperity or security? Have you ever reached over and locked the doors to your car when you approach a group of people who are a different race than you? These questions are not meant to blame. They are meant to get us all thinking about those beliefs and biases we may not even realize are influencing our thoughts and actions as mandatory reporters. As we now talk about warning signs of abuse, consider your personal beliefs and biases and how they may affect what you see or hear. What are the warning signs? We group them into 3 categories: physical signs present on the child, behavioral signs or statements made by the child, or behavioral signs or statements made by the parent or caregiver. Physical signs present on the child may include injuries on parts of the body that are not typical. Kids bruise their shins, bang their knees, and scrape their elbows. These are expected for active children. However, injuries to their back, neck, buttocks, or genitals are more likely to be associated with abuse. Injuries for which the child has no explanation or a reason that isn't logical. Medical, dental, vision, or mental health needs that appear to go unaddressed. Poor height or weight growth when there is no identified medical cause. Or a child who has a sexually transmitted infection. Behavioral signs or statements made by the child may include regularly runs away from home, the appearance of extreme fatigue on a regular basis, a pattern of stealing food or complaining of hunger, a child who cries, cowers, or otherwise indicates that they do not feel safe in the presence of a parent or caregiver, losing skills already developed, including incontinence when potty training has been well established, attempting suicide or displaying behaviors that self-injure, statements about being unsupervised before they can safely care for themselves, statements they fear their parent or caregiver or don't want to go home, asking others to supply necessities, or direct statements about experiencing abuse. Behavioral signs or statements made by the parent or caregiver may include disregard for the child's feelings, needs, or emotions, seeing the child as entirely bad, evil, or worthless, describing the child in sexual terms, or implying that the child may provoke sexual contact from others, expecting the child to behave in ways unrealistic for their abilities or development, seeming to purposely isolate the child, including removing them from school or other activities, or offering conflicting, unconvincing, or no explanation for injuries or events. While parents with disabilities may need different kinds of support to raise a child, a disability or mental health condition alone does not constitute abuse. When you notice one or more signs, you may be unsure whether abuse has occurred and whether you need to report. But you should think critically about what else you know and what you've observed from that child and family. Never second-guess yourself if you believe a child has been abused. However, if there is a question in your mind and the family involved happens to be a family of color, consider personal bias. The Child Welfare Screener will help sort out your concern. It's better to report or discuss concerns with a professional who can help than to remain silent. Common situations that cause concern for mandatory reporters. In addition to the indicators discussed previously, mandatory reporters often become aware of specific circumstances that raise concern about a child's safety and well-being. Let's address these situations so you have a better understanding of how child welfare considers each one. Domestic violence. Domestic violence means a pattern of coercive behavior, which can include physical, sexual, economic, and emotional abuse that an individual uses against a past or current intimate partner to gain power and control in a relationship. Exposure to domestic violence is not considered child abuse in and of itself. However, there is a high incidence of child abuse in families where domestic violence is occurring. When a child has experienced an injury, expresses concern for their safety related to domestic violence, or when you believe the child will be harmed related to domestic violence, report it. Physical discipline. Physical discipline that is reasonable and appropriate to the child's age, size, and development is not considered physical abuse. Physical discipline is not permitted in public schools, licensed child care, or state-licensed or certified care such as foster homes, group homes, or child-caring agencies. Unsupervised children. Oregon laws do not designate the age when a child can be left unsupervised. However, a child under the age of 10 cannot be left unattended for such a period of time as may likely endanger their health or welfare. Age is not necessarily a good indicator of a child's ability to keep themselves safe without supervision. A child's maturity level, ability to meet their own needs and act appropriately in an emergency, along with the physical safety of the home environment, are all factors when considering whether a child may be experiencing neglect by being left home alone. Failure to obtain medical care. A parent or caregiver failing to obtain care for an obvious or identified medical, developmental, dental, vision, or mental health need may constitute child neglect. Generally, the failure is likely to result in a significant health issue for the child. For example, a caregiver who does not provide ongoing treatment for a child with asthma or diabetes risks a significant consequence for the child, up to and including death, if the condition isn't regularly monitored and care delivered. On the other hand, a caregiver who delays a doctor's visit for weeks for an ongoing cough and runny nose, even when others note concerns, may not be making the best choice, but wouldn't be considered neglectful under the law, because the outcome isn't likely to be serious. Substance use during pregnancy. Concerns about newborns who show symptoms of exposure to substances or have been known to be exposed before birth should be reported to child welfare. Federal law requires that state child welfare agencies have procedures to assess whether these children affected by substances will be safe and well cared for if discharged into the care of their parents. Oregon cannot assign reports of child abuse concerning expectant mothers with no children in the home. However, it is best to document concerns about parental behavior, conditions, or circumstances that may endanger a newborn child prior to the birth. This information would be considered if child welfare received a future report once the child is born. This section described key indicators that child abuse may be occurring, common situations that are often concerns for mandatory reporters, and the importance of considering the impact of personal views and biases on reporting. Next, we will review the types of information you will want to have on hand when making a report.
When contacting the Oregon Child Abuse Hotline to make a report of abuse, keep a record of the date and time you called and the name of the person to whom you spoke. When making a report, it is helpful to have as much information as possible about the child, the family, and the situation. What information should I have? Provide information about the extent of the abuse and the circumstances surrounding the abuse. It's helpful to include any history of previous episodes of abuse you suspected or are aware of. If known, provide the child's, parents, and caregivers' full legal names, dates of birth or approximate ages, current locations, and contact information. You should also provide names and contact information for non-custodial parents, siblings, and other children and/or adults living in the home. Additional useful information, if you have it, may include name of school or daycare, the family's preferred language and whether an interpreter is needed, any concerns regarding the safety of a worker assigned to assess the child's situation, general functioning of the child, including medical diagnosis, disabilities, or unique care needs, observations or statements made to you or others about the child's functioning, information that leads you to suspect domestic violence, observations or concerns about substance use, indications of mental health impairment in the parent, or anything that seems to affect the parent's ability to adequately and safely respond to the child's needs. If other concerns have ever been discussed with the family, whether by you or someone else, report the reaction and what steps were taken to address the situation with the family. It is also important to report about what is going well in the family. Information about strengths, successes, and areas of no concern can help paint the whole picture. This includes information about the family's support system, such as the presence of extended family, involvement in the community or religious groups, cultural supports, or other resources. Again, this is helpful information if you have it, but you are required to report concerns even when you do not have all the requested information. Finally, federal law and Oregon law require child welfare to identify any Native American and/or Alaska Native ancestry related to the child and their biological parents. It is critical to know whether the child or parents are Native American and which tribes they may be affiliated with. The law states that federally recognized tribes have a right to intervene in cases involving members or possible members of their tribe. Oregon state law affirms our commitment to work with tribes to ensure the safety and well-being of their children and families. Child welfare works closely with tribes to make sure this occurs. This section described the type of information you should be prepared to share, if known, when you make a report.
Now you will learn about making a report itself, including when and to whom the report should be made. You'll also learn what may happen as a result of a call to a child welfare screener. If you witnessed possible abuse, you are the responsible reporter. You cannot ask someone else to make this report for you. By providing your name, relationship to the child or family, and contact information, you have met your responsibility as a mandatory reporter and allowed child welfare staff to contact you if needed. Failure to report is a violation of the law and carries a maximum penalty of $2,000. Mandatory reporters can also be sued for damages in civil court for failing to report. In Oregon and in most other states, there are laws that keep the names, addresses, and other identifying information about the person who makes a child abuse report confidential. A small number of cases may involve criminal or juvenile court action, and you may be called as a witness. The law requires a report of suspected child abuse be made immediately. So as a mandatory reporter, you are required to report child abuse 24 hours a day, 7 days a week, regardless of whether your knowledge came in your official capacity or outside work hours. Reports can't wait until later, a more convenient time, or the next business day, even if the child is not currently in danger. For example, if you stop for groceries on your way home from work and observe child abuse in the checkout line, you are still required to report and must report immediately. If you think someone is being hurt now or is in immediate danger, call 911. For all other reports of child abuse, call the Oregon Child Abuse Hotline at 1-855-503-SAFE or contact your local law enforcement agency. The screener who answers your call will ask a wide range of questions regarding the child, family, and your specific concerns. Once the information is gathered, a response will be determined. When the report is assigned for CPS assessment, this means child welfare assigns someone called a CPS worker to meet with the child and family to determine whether abuse occurred and assesses the safety of the child. The CPS worker assigned to the child and family may contact you to discuss your concerns. It is the role of child welfare to protect children from current and future abuse. It is only when it appears there is no way for a child to be safe in the care of their parent or caregiver that child welfare, law enforcement, or the courts may intervene to remove the child. Such actions are intended to be temporary and must be supported with evidence. Even when children are removed from their home, the law requires that ongoing efforts be made so that the child may be safely returned to their family as soon as possible. The ultimate goal of intervention is the safety of the child. Not all reports are assigned for CPS assessment. When the screener determines the information gathered does not meet criteria to assign, the report may be closed at screening. When a report is closed at screening, the information is still recorded, and if another report is made about any child or adult in the family in the future, the previously reported information can be reviewed. Even when a report is closed at screening, there may be other agencies in the community who may be able to help and support the family in meeting the child's needs. Once you make a report of child abuse, the screener or CPS worker can tell you whether the report was assigned, whether abuse occurred, and whether services were offered to the family. As a mandatory reporter, you have met your reporting obligation whether or not the report is assigned for CPS assessment. While it can feel disappointing when the outcome isn't what you expect, know there are many avenues where a child and family can be helped. If you have concerns about a screening decision, you may ask to speak to a screening supervisor.
Thank you for taking time to learn more about your role as a mandatory reporter
You are often the critical link between a child who needs help
and a response that can offer protection and support.
when you use your professional skills to recognize the signs of abuse.
Record critical information to prepare for making the report.
Then report that concern.
You are fulfilling your legal obligation and using your voice and power on behalf of a child who is counting on you.
Thank you for the many ways you contribute to our state and your communities.
You are part of the safety net for children and families, and it truly matters.